Hello guys, a very good afternoon to everyone. Welcome to Global Online Platform. Here we are preparing for NTA UGC NET June 2024 cycle. Here today we are going to discuss the 25 most expected MCQs on the Competition Act 2024, which comes under the unit number 9, that is the legal aspect of the business. So before we are going ahead with the MCQs, expected MCQs, let I will shortly tell you about the course we have going to provide you. This batches is started from the 29th of the April, so get hurry. Okay, so here we are going to provide you complete course on the commerce and management. Okay, so here we are going to provide you the daily live lectures. Okay, you can clear your doubt in the daily live lectures with your teacher. And here we are going to provide you the complete syllabus note that which you get download in your in the PDF form in your mobile. You can learn, you can do your study in anywhere at any time. And then the full syllabus mock test is also we are going to available to you. Then the PYQs with a detailed solution we also going to discuss with you. Then more than the 4,000 MCQs practices session we are going to conduct. And here you will get paper 1 is free of cost if you register yourself for the paper 2. Okay, and for the in these fees you will get a 20% of the discounts on these fees. So in this amount you will get a paper 2 plus paper 1 is free of cost. Okay, if you register yourself for paper 2, you will get paper 1 is free of cost. So either here is in your screen there is a contact number is given below. So get in touch with this contact number. Okay, now let's moving ahead with the first question. That is a CII consists of a dash appointment by the central government. You have to first know the full form of the CII. So what is the meaning or what is the full form of CII? CII means competition competition commission of India. Okay, this is the full form of CII. So here is the options is given in your screen. That is option number 1, chairperson and 6 member. Option number B, director and 6 member. Option number D. Option number C, director and 4 member. And option number D, chairperson and the 4 member. So what will be the right answer? You have to know that this is a factual question. So in this kind of question, no buffering will be work on. Okay, so you have to be very specific with this kind of question. So what will be the right answer? The right answer is option number A, that is chairperson and 6 member. Okay, so what is the right answer? That is chairperson and the 6 member. So ICCI consists of chairperson and 6 members appointed by the central government. Who going to appoint? Who was appointed? The central government has appointed. Okay, now the question number 2. Dash is not a type of agreement under the Competition Act. Option number the options is given in your screen. That is this is an also an factual question. Today's we are going to take a factual questions which there is you have to know these questions. So you have to learn, you should to learn this kind of question. You have to remember this kind of question. So option number 1 is a horizontal agreement. Option number 2, hybrid agreement. Option number C, vertical agreement. Or option number D, none of the above. So what will be the right answer for this question? So I will tell you that is not a type of. Read the question carefully. Okay, so it's talking about a not a type of. So first of all, we have to know that is a what are the types of the agreement in the Competition Act. There are the 3 types of agreement in the Competition Act. That first one, that is horizontal. Okay, second one is a vertical, and third one is a hybrid. Okay, so horizontal means in a same level. Okay, like a wholesaler to wholesaler, retailer to retailer, and the manufacturer to manufacturer. What is a vertical? Vertical means down to up or up to down, like manufacturer to retailer to manufacturer, or manufacturer to retailer. And hybrid means this is a combination of the horizontal and the vertical. Okay, so this is a combination of the horizontal and the vertical. Okay, so the option here you can see is talking about is not a type of, so you have to, you know that there's a horizontal is an agreement, hybrid is also an agreement, vertical is also an agreement. So the option number D is the correct answer, the none of the above. Okay, clear? Now moving toward the question number 3, dash cannot be appear before the commission. Dash cannot be appear before the commission. The question is about which is not come before the commission. Okay, so there is an option given in your screen, that is option number 1, regular banking officer, option number B, company secretary, option number D, director general, option number his option number C, option number D, chartered accountant. So what will be the right answer? So right answer here is option number A, that is the regular banking officer is cannot appear before the commission. Okay, so company secretary can, director general can, and CA can. Okay, now all the questions which I'm going to take today, it's all questions are a factual questions. Okay, there is no rocket science behind of that question. You have to learn, you have to remember this kind of question. Okay, that's why I'm taking the, because from the Competition Act, every year, every in examination cycle, they ask the question from these area, and they actually ask the question from the factual question most of the time. So we have to be careful and we have to learn this question. I'm just hoping that you have to learn from this question. Okay, you have to remember this kind of question. So question next question, that question number 4, dash is a penalty for failure to compile the direction of the commission and director general. If what are the in this question he's talking about the penalty, okay, for the failure to comply. So we have to recognize that which is the correct option in this statement. So here is the option statement number 1, that is it's statement number A, statement number B, and statement number C, and statement number D. So what is the statement number A? Rupees 1 lakh for each day during which such non-compliances occur, subject to the maximum of rupees 100 crore. B, 1% of the total turnover of the assets, subject to the maximum rupees 10 crore. Option number C, such person shall be punishable with a fine which may extend to the rupees 1 crore. Then the rupees 1 lakh for each day during the such failure continue, subject to maximum rupees 1 crore. So here is the right answer for this question, that is option number D. If the penalty, what is the penalty? Rupees 1 lakh for each day. Rupees 1 lakh for each day during such failure continue is a suppose they are unable to, suppose they are one company, A company and B company. So these two company are want to acquire. Okay, so if the A company want to acquire the B, in that case the A company must to inform to CII. Okay, CII will make sure that all are the conditions which is not against them, against the Competition Act. Okay, if it is going to against the Competition Act, in that case CII are going to cancel it. If the A and B company have failed to continue to clear their concept before the in the front of the CII, in that case it is subject to maximum rupees 1 crore as a penalty. Okay, so the option number D is a correct answer over here. Now the question number 5. Dash has power to exempt the enterprises practice or the agreement for the application of the Competition Act 2002. Okay, so in this question, actually he is talking about the power. Has a power to exempt the enterprises practices or agreement from application of Competition Act 2002. So what will be the right answer? The right answer is that is the central government has a power, okay, to exempt the enterprises practices and agreement. Who having a power? The central government having a power. A power under the Competition Act 2022. Again, this is a factual question. You have to remember, you have to learn this kind of question. Next question in your screen, that is what as per the Competition Act 2022 refer to the sale of goods, provision, services at a price which is below the cost to eliminate the competition. Okay, so for eliminating competitors, what the price for below cost, if they are selling, if they are providing services or selling the goods to the to the customer in the below the cost to eliminate the competition. So this kind of what is the what so this kind of operation is called as MRP, predatory prices, and preparatory prices or GST prices. So what will be the right answer for this question? The right answer will be option number B. Okay, so right answer will be option number B. Option number B, that is predatory pricing. It is a pricing at which low cost to be eliminate the competitors. Okay. Now moving toward the next question, question number 7, that is dash is a horizontal agreement. You can see this this is a very short and very simple. You can see this question is very short and simple, but this is also and the factual question. You have to remember this kind of question. So is a horizontal agreement. What I said that what is the horizontal agreement? Which agreement is between the same level? Between the same level. Okay, in that case the horizontal agreement is going to come. Okay, so here is a manufacturer to manufacturer, retailer to retailer, wholesaler to wholesaler. Okay, so what will be the right answer for this question? The right answer will be option number C, that is cartel. Cartel is the horizontal agreement. Okay, so another, that is a tie-in agreement, resale price maintenance, exclusive distribution. So this comes under the hybrid and vertical. Okay, now see the correct answer over here. You can see now. The question number 8, which is in your screen, the Monopoly and the Restrictive Trade Practices Act 1969, the MRTP Act, stand replete and replaced by the Competition Act 2022, which with the effect from. Okay, so with effect of from, actually here in this question he is talking about the Competition Act Competition Act 2002 when it come into the force. Okay, so actually this question is talking is asking about the when the Competition Act 2002 come into the force. Okay, so you have to know that there is a 7 years of difference between when the parliament passed the bill and when is come to force. So there is a difference of this 7. So here we add, that is 2009. So here you can see the option number C is the correct, that is the 1st September 2009. In this date, the Competition Act comes into the force. Okay, now this is the C is the right answer over here. You can see. Now, next question in your screen, that is the operator independently of the competitive force prevailing in the relevant market dash competition. So option number A, anti-competitive agreement. Option number B, abuse of the dominance. Option number C, combination of regulation. And the option number D, competitive advocacy. So first of all, you have to know about what these terms are talking about, what these options are actually meaning of the of these options. Okay, so the anti-competition agreement is a kind of anti-competition agreement to prevent or ban on the anti-competition. Okay, so anti-competition means the which is opposed to the competition. Okay, now the abuse of dominance means the monopolist who abused his using his dominance is abusing the customer and the local area. Okay, and the combination regulation means it's kind of amalgamation. Okay, and it's kind of acquisition. Okay, when the amalgamation between the two companies, when the one company acquire the another company, so this is a acquisition, that is a combination rule or regulation. Okay, now the competitive advocacy is a different thing. So for this question, I will read this question again. I'm going to read this question again. Operate independently. He is talking about the independently of the competitive force prevailing in the relevant market. In the relevant market, independently, if you can remember one example of the railway. Okay, railway having an independent operation and of the competitive force is prevailing, because if the railway is changing his fee structure, so the his prevail the relative market also. Okay, so the option number B is the correct answer. That is actually what is railway going to, for example, the railway. Okay, so what is actually the railway is going to do? That means he is doing the using his dominance place and dominance place to abuse his abuse the market, relevant market. Okay, now moving toward the next question, which one of the following is not a duty of the competition? It's not the duty of Competition Commission. That is CCI, Competition Commission of India. So what will be the right answer? So here we will see. Here we are going to see the option number A, to protect the interest of the investor. Yeah, interest of the investor. Okay. Option number B, to ensure the freedom of the trade carried on by another participation in the market in India and for the matters connected therewith and incidental thereinto. Option number C, to prevent the practices having an adverse effect on the competition. That means anti-competition. Okay. Then to promote and sustain the competition in the market. So what will be the right answer? In this question, this question is for the is not. It's not a duty. Okay, of the CCI. So the first duty of the CCI is to ensure the freedom of the trade. Okay, so first duty is to ensure the freedom of the trade carried by the other participant in the market in India and for matter connected therewith incidental thereto. Okay, the another option is to prevent the practices having an adverse effect on the competition. That is the anti-competition is also the duty. To prevent the anti-competition is also a duty of the CCI. Now, it's also the duty of the CCI to promote and sustain the competition in the market. Okay, the actual aim of the Competition Act to sustain the competition in the market and to see the welfare or the of the customer. Okay, now that is option number B is not for the investment, to protect the interest of investment. No, to protect the interest of the customer. Okay, for customer. Okay, so option number A is a correct answer for this question. Now, next question in your scheme: who can make a reference on the competition policy in formulating a policy related to the competition or in any other matter may seek the opinion of the commission by making the reference to it. So option number 1 is in your screen, that is the central government, B is a state government, A and B central and state government. So this question and option number D, chairperson and other member of the competition commission of India. So what will be the right answer? Actually, this question is about who can make a reference on competition policy in the formulating policy related to the competition. Who having authority? Who can change in the competition policy? So central government also having a authority and state government is also having authority. So the option number C is the correct answer over here. Okay, now the question number 10, what is the minimum number of the member to be appointed by the central government in the CCI as per the Competition Act 2022? So how much minimum number of the member to be appointed by the central government in CCI? So right answer will be, that is option 2. Okay, 2 members to be appointed by the central government in CCI. Okay, hope so you're also learning or the remembering this this most important MCQs. Okay, now question number 30. How many numbers of day for the notice is to be given to CCI while an enterprises process to enter into the competition as per the Competition Act? So in this question is talking about the CCI. CCI is a very important topic of the Competition Act, and here from these MCQs we can learn many things, many factual things about the CCI. Okay, so you have to remember the how many numbers of day of notice is to be given by the CCI. So who is giving notice? CCI. To whom? The enterprise, to the enterprises. Okay, while the enterprises process to enter into the combination. Okay, so who giving the notice? The CCI giving the notice to the combination of either amalgamated company or the acquired company. Okay, acquisition of the company as per the Competition Act. So the right answer will be, that is option number 30 days of the notice. 30 days of the notice is to be given by to the ICSI while enterprises proceeding to enter into the competition. Now the option number question number 14. The chairperson and other members shall not for a period or for the date on which they cease to hold office accepted by the employment in or be connected with the management or administration of any enterprises which has been a party to proceed before the commission. So this is an actual factual question. Now here you can see the chairperson and other members shall not shall not for the period of from the date on which they have ceased. Okay, they have ceased to hold office, accepted any employment in or be connected with the management or administration of any enterprises which has been a party to proceeding before the commission. Okay, so what will be the right answer to this question? That is option number C, that is 2 years. The 2 years of the period of the date on they have to be ceased. Okay, so 2 years of the date have been provided by the chairperson and the other member. Okay. Now, the question number 15, is there compulsory wait period for the combination to take the effect? Option number A, yes, the proposed combination cannot be effect from the period to 10 days from the date it notify the commission or till the commission passes an order, whichever is low. Option number B, no, the proposed combination can be take effect from the date of the commission pass in the order. Yes, the proposed combination cannot be take effect from the period of the 60 days from the date is notified in the commission until the commission pass in the order, whichever is earlier. And option number D, no, the proposed combination can be taken effect from immediately after the date to notify the commission until the commission pass on the order, whichever is earlier. So actually, this question is about is there is a compulsory wait period for the combination to take in effect? Yes, the option number A is the correct answer. That is 10 days from the date is notified. Okay, so it is a compulsory. Yes, it is a compulsory to wait a period for the combination to take in effect. And how many days? 10 days from the date to be notified the commission or till the commission pass an order, whichever is earlier. Okay, the question number 16, that is CCI shall not initiated an inquiry into combination after the expiry of dash year from the date on which the combination takes place. Is talking about the CCI shall not initiate an inquiry into the combination. Okay, combination after the expiry of the option number C is the correct expiry of the 1 year. Okay, after the 1 year is passes, so no inquiry is initiated, okay, into the combination after the expiry of 1 year from the date on which the competition has been taken effect. Okay, sorry. Now question number 17, an appreciable adverse effect on the competition in the relevant market in India is uh, set to taken place when? So the question is about an appreciable adverse effect on competition. So what is the adverse effect on the competition in the relevant market in India is said to be taken place when an agreement referred to an in section 3 has been entered into outside any enterprises abuse a dominant position in India. Yes, this is also true. And enterprises abusing the dominant position in India, this is also true. So what will be the right answer? That is option number D is the right answer. That the adverse effect on the competition is relevant in the market is said to be placed when the agreement referred in the section number 3. So what is this? First of all, I have a question. What is section number 3? Section number 3 is for the anti-competition. So the anti-competition is given in the section under section 3 has been entered in the outside, and option the next, any enterprises abusing the dominant position in outside in India. Okay, yes, this is also true. Any enterprises abusing the dominance position in India. Yes, this is also true. So the option number D is the correct answer. Okay, now anti-competitive agreements are void from the starting. Okay, is void. Option number B is the correct answer. Now, which of the following as per the Competition Act 2002 refer to any agreement which is restricted or likely restricted by any method sorry method for the persons or classes of a person to the whom the goods are sold, from the whom the goods are brought. Okay, so what is that? That is the refuse to deal, exclusive distribution agreement, or the tied in agreement, exclusive distribution agreement. So what will be the right answer? That is refuse to deal. So what is refuse to deal? That is any agreement which is restricted any method to person to class persons or classes of the person to whom the goods are to be sold, from whom the goods are bought. So this is refuse to deal. Okay, this is a refuse to deal. The option number A is the correct answer. Now the question number 20, that is competition bill. Okay, become an act after the receiving the asset from the, this is a really baby question, that is from the president on India, president on which date? Which date? Option number B, that is 4th of December 2005. The competition bill become an act after receiving asset from the president on competition bill become an act after receiving the assent. The option number B is not right answer. Option number A is right answer. The competition bill become an act after receiving assent from the president on the 15th of April 2002, because Competition Act is 2002. So the correct answer for this question, that is 15th of April 2002. Question number 21, merging and amalgamation of the enterprises shall be combination if the group to the enterprises will belong after the acquisition jointly having in India. So what will the right answer for this question? This is also factual question. The asset is greater than 8,000 crore and turnover is greater than 25 crore. Asset is greater than 2,000 crore and turnover is greater than 6,000 crore. Asset is 1,000 crore or turnover. Asset is 1,000 more than 1,000 crore and turnover is more than 3,000 crore. So what will be the right answer? That is option number A is the right answer over here. Okay. Then the central government may be notified supersede the commission for such. The option number 1, not exceeding 6 months. Option number B, not exceeding 9 months. Option number D, 4 months. Option number 8 months. So what will be the right answer? That is option number B. Option number B, that is not exceeding 9 months. It must not be exceeding 9 months. The central government may be notification. Okay. Supersede to the commission for such is 9 months, not exceeding 9 months. Okay. Now the question number 23, that is dash cannot be considered as the goods under section 2 of the Competition Act. So option number 1 is given your screen. That is a product manufactured, proceed or mining. Yes, this is comes under this under the definition of the goods. Then in relation to the goods supply, distribution controlled in India, goods imported in India. So this is also comes under the goods definition. Debenture, stock and share before the allotment. This is not come under the goods. Okay, so the option number C is the correct answer. Now, what order the commission can pass in case of the combination? What order commission can pass in case of combination? Option number A, that is it shall approve the combination if no appreciable adverse effect on the competition is found. Option number B, it shall disapprove the combination in case of the appreciable adverse effect on the competition. Option number C, it may propose a suitable modification, or option number D, all of the above. So what will be the right answer for this question? That is option number D, that is all of the above. What order commission can pass in case of combination? First of all, they shall approve the combination, no appraisal adverse effect on competition. they must be careful about this. It should be approve the competition in case of the appreciable adverse effect on the competition. It may purpose a suitable modification. Okay. Now this is our last question of this session, that is the office holding terms and age limit of chairperson of the competition commission is option number A, which is given in your screen, that is appointment for a terms of 5,000 sorry 5 year. However, the maximum age limit is 67. Appointed for the term for the 5 year, however the maximum age is 65. Appointed for the terms 5 year, however the maximum age is 64. Appointed for the terms for 5 year, however the maximum age is 62. So what will be the right answer? The age of the, here is actually about the age of the chair competition commission, that means age of the chairperson of the CCI. Okay, so what will be the right answer? That is option number A, that is 67. Okay, the age limit is 67. So thank you so much for, and please stay tuned with us. You will get a many more MCQs session with different MCQs, and you will get clear your doubt from this session. Okay, so thank you everyone.